All right, so today we are going to talk about the Fourth Amendment. And this amendment governs the interactions between individuals and law enforcement, and they are intended to protect us from overzealous governmental intrusion. And if you guys hear my children in the background, I'm so sorry. I have headphones on, so I can hear them kind of, but not really. So I don't know how it's translating to the recording. But let's begin, as always, with the text itself. So the Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, support by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay. So this single sentence, that is all one sentence, it encapsulates some of the most vital protections that individuals have against government intrusion. The Fourth Amendment provides a few core protections, which I just read them to you, but let's break them down into individual segments. So, first and foremost, it protects us against unreasonable searches and seizures, but it doesn't prohibit all searches, only those that are deemed unreasonable by the courts. Okay. Second, it protects us against unreasonable seizures, whether of our persons, like an arrest or detention, or of our property. Third, it establishes a general requirement for warrants. The second part of the amendment is often actually called the warrant clause, and it details what a valid warrant must contain. And then finally, it also demands that these warrants be issued only upon probable cause. And that is a crucial standard, which we're going to define. But again, remember our discussion from before. So while the Fourth Amendment literally says the rights of the people shall not be violated through the process of the incorporation via the 14th Amendment's due process clause, these protections against federal action have been extended to apply to with equal force to the state and local governments as well. So this is why the Fourth Amendment is so critical in cases involving local sheriffs, municipal authorities, state police officers, things like that. Now, one last thing that I want to add here before we kind of dig in is that the ultimate goal of the Fourth Amendment is supposed to be to strike a balance, to protect an individual's privacy and security from arbitrary governmental intrusion, while allowing government and law enforcement to effectively investigate and prevent crime. And the balance is, it's difficult to achieve. There's no other way to say it. So now, before we dig into what constitutes a search and seizure, we have to first understand the most significant standard of suspicion under the Fourth Amendment, which is probable cause. So this term appears directly in the Fourth Amendment's text, stating that warrants must be issued upon probable cause. Okay, so probable cause is defined as a fair probability or substantial chance based on trustworthy facts and circumstances that contraband or evidence of a crime will be found in a particular place, or that a person has committed or is committing a crime. And this is the standard for lawful arrest and for obtaining search warrants. So the standard is more than just a mere hunch or a suspicion, okay? It is considerably less than the proof that's required for beyond a reasonable doubt, which you use for a conviction at a trial. But it is often described as a reasonable belief or a substantial chance that a crime has occurred or will occur, or that evidence is present at a location. It does not require certainty, only probability. Okay. So probable cause can come from various sources. You can have an officer's direct observation and experience, meaning an officer seeing someone openly carrying illegal drugs. That counts. Then you have information from reliable informants. So if you have a tip from a known, reliable informant, especially if it's corroborated by other police investigations, that's going to work. So, for example, If a known reliable informant tells police that drugs are being sold from a specific apartment, and then police then observe frequent short visits to that apartment, that would be considered consistent with drug dealing, then the informant's tip would technically be corroborated. So let's talk about getting information from other police officers. This leads us to the collective knowledge doctrine. And this doctrine states that probable cause can be established by the collective knowledge of all officers involved in an investigation, even if no single officer possesses all of the information individually. Okay, so this knowledge is imputed among the officers, meaning that what one officer knows, then all officers involved in the case are presumed to know for the purposes of establishing probable cause. Okay, so for example, if Officer A observes a suspect engaging in behavior that would be consistent with drug dealing and radios in the information to Officer B, Officer B, relying on Officer A's information, stops the suspect as they're driving down the road. So even if Officer B alone didn't personally observe all of the suspicious behavior, the collective knowledge of Officer A and Officer B can establish probable cause for the stop or the arrest. Okay. You also have other ways like forensic evidence, which would be like a DNA match or fingerprints that are found at a crime scene. You also have victim or witness statements, which credible accounts from victims or witnesses describing a crime and identifying a perpetrator would be enough. But the key is that probable cause has to be based on objective facts and circumstances, not just an officer's feelings or hunches. It's a critical check on police power. Again, to try and ensure that intrusions upon liberty are going to actually be based on a solid foundation. So while probable cause is the standard for arrest and warrant, the Fourth Amendment also recognizes a lower standard of suspicion for less intrusive encounters, and that is reasonable suspicion. So reasonable suspicion is defined as a particularized and objective basis for suspecting that the person stopped is involved in criminal activity. So it's a pragmatic standard. It allows police to briefly detain and investigate suspicious individuals, okay? But without having to meet the high bar of probable cause. So the officer must be able to articulate specific facts that, when combined with their training and experience, lead them to believe that criminal activity is happening, okay? So the standard is lower than probable cause. So it's still more than a hunch, but it's definitely less than probable cause. It requires specific and articulable facts, which, taken together with rational inferences for those facts, reasonably warrant the intrusion, okay? So it cannot be based on an officer's, inchoate, that means, and we'll talk about those, like an unparticularized suspicion or hunch. Again, it needs to be something more concrete than the officer can explain, okay? So for example, if an officer sees a person kind of nervously pacing outside of a jewelry store at 3 a.m., repeatedly looking in, wearing heavy clothing on a warm night, quickly ducking behind a car when the patrol passes, those specific observations, combined with the officer's experience, could create reasonable suspicion for the person and them casing the store for robbery. And the primary context for reasonable suspicion is the stop and frisk. It is the detention for investigation purposes and to pat them down for weapons, which we're going to discuss in detail later. But this doctrine is established in Terry versus Ohio, and it does allow for brief detentions based on reasonable suspicion. Again, balancing individual liberty with officer safety and crime prevention. I know this is another topic that we can probably argue about all day too. But again, don't shoot the messenger. So let's start with the old standard. The first fundamental question when analyzing a Fourth Amendment claim is, was there a search by the government? If there was no search, then the Fourth Amendment simply doesn't apply. The Supreme Court's definition of a search has evolved significantly, really, over time. And it's moved away from a purely physical concept to one that takes into consideration any privacy expectations. So the old standard for a search was purely based on a physical trespass. And that would be like what was used in the Olmstead versus United States case. And this is where the court held that wiretapping telephone lines outside of a suspect's home was not a search because there was no physical intrusion into the home, okay? Or there was no seizure of a tangible item. But this narrow view kind of focused solely on physical invasions of a constitutionally protected area, like, say, a house. And those areas are listed in the Fourth Amendment. I mean, let's be real. It says persons, houses, papers, or effects. But again, this narrow view was profoundly challenged in the landmark case of Katz versus United States, which introduced the concept of reasonable expectation of privacy. So Charles Katz was a bookmaker who used a public telephone booth to transmit illegal gambling wagers. And unbeknownst to him, FBI agents had attached an electronic listening device, and it recorded actually, to the exterior of the phone booth, and they recorded his conversations. And this evidence was used to convict him. And Katz argued that the recordings were obtained in violation of his Fourth Amendment rights because they constituted an unreasonable search, even though there was no physical entry into the booth. So the question before the court was, did the FBI's electronic listening and recording of Katz's conversation in a public phone booth without a warrant constitute as a search under the Fourth Amendment, even though there was no physical trespass to the booth itself? And the Supreme Court said that the FBI's actions did constitute a search and that it was unreasonable without a warrant. So Katz's conversations were therefore inadmissible as evidence. So Justice Potter Stewart wrote for the majority, and he actually famously wrote that the Fourth Amendment protects people, not places, okay? And the court ruled that what Katz sought to preserve as private, even in an area that is accessible to the public, may be constitutionally protected. Now, the crucial part of this decision came in Justice John Marshall Harlan's concurring opinion, which articulated a two-part test for determining a reasonable expectation of privacy, which has become the dominant framework for defining a search. So the first thing was, did the individual exhibit an actual, subjective expectation of privacy? So did Katz personally believe that his conversations were private when he closed the phone booth door? Well, yeah, his actions kind of indicated that, right? The other was, is the expectation one that society is prepared to recognize as reasonable, which is the objective part? So would society deem his expectation of privacy in a closed phone booth conversation as legitimate? And they said, well, yes. So because both prongs were met, the court found that a search occurred. So since the search was conducted without a warrant and no exception was applied, it was unreasonable. So this decision fundamentally shifted the focus of the Fourth Amendment's analysis from mere physical trespass to a broader concept of privacy that society is willing to protect, especially in the face of new surveillance technologies. So the impact of Katz basically revolutionized the Fourth Amendment jurisprudence. It expanded the definition of a search to include non-trespassory invasions of privacy, making technologies like wiretapping subject to Fourth Amendment constraints. And it established the reasonable expectation of privacy test, which remains central to defining exactly what a search is today. And this was a critical step in adapting the Fourth Amendment to a world of evolving surveillance technologies. So, based on the CATS test, courts have developed understandings of privacy expectations in various areas. So, let's start with homes. Um, Without a doubt, individuals have the highest expectation of privacy in their homes. So, any physical entry or technological intrusion into a home is going to, or actually, let me say, any intrusion into a home to obtain information is generally going to constitute a search. Okay. Next is the curtilage, and this refers to the area that is immediately surrounding and associated with the home, and it is typically treated as an extension of the home itself for Fourth Amendment purposes. And this includes areas like a front porch, a fenced-in backyard, an attached garage, things like that. And searches of those areas are generally going to receive the same kind of heightened protection that the home would itself, okay? And Florida versus Jardines, which we're going to discuss, is a key space or a key case here. Got ahead of myself. Next is airspace. And generally, individuals have no reasonable expectation of privacy from aerial surveillance, okay? Even by relatively low flying aircraft like helicopters or planes, even, as long as they're operating in the public navigable airspace and they're observing things that are visible to the naked eye. Okay. The reasoning is that anything visible from public airspace is not truly private. Then you have your public places and your open fields. And in general, there is no reasonable expectation of privacy in public places. That would be sidewalks, parks, public streets, or in open fields like areas of private land that are not part of the home's curtilage, even if it's fenced off. Okay. And police can observe activities in these areas without conducting a search because, again, they're openly accessible or observable by others. All right. So while CATS expanded the definition of a search to include privacy expectations, in recent years, the court has, in some instances, reaffirmed the relevance of a physical trespass in defining a search, kind of operating as an independent basis alongside the CATS privacy test. So this means that a physical intrusion into these protected areas, you've got your persons, your houses, your papers, and effects, it can still be a search regardless of whether a CATS privacy expectation is technically violated. And a key case for this is United States versus Jones. And you guys, I think, will love this one. But this is where law enforcement suspected Antoine Jones of drug trafficking, and they obtained a warrant to install a GPS tracking device onto his car, but installed it after the warrant had expired and outside the jurisdiction of the warrant. So they then used the device to monitor his movements on the public roads for 28 days. And the government argued that since Jones was traveling on public roads, he had no reasonable expectation of privacy in his movements under CATS, since his movements were considered observable by the public. Okay. So the issue was the attachment of this GPS device to a vehicle and then its use to monitor the vehicle's movements on a public street, a search under the Fourth Amendment, rather. And the Supreme Court unanimously held that the government's installation of this device onto Jones's car and then to use it to monitor the movements absolutely constituted a search. Okay. Now, I have to say the majority did not rely exclusively on the CATS privacy test, though. So you have Justice Scalia, who is writing for the majority, and he found that the government had engaged in a physical trespass to Jones's effect, which was his car, by installing the device. And this physical intrusion combined with an effort to obtain information was sufficient to constitute a Fourth Amendment search, regardless of whether a reasonable expectation of privacy was violated in his movements on a public road. Okay. So the court thus kind of revived and reaffirmed the traditional Fourth Amendment trespassery test as an independent basis for finding a search, stating that the CATS privacy test kind of just added to it. It didn't replace it. it didn't replace the traditional trespass test, that is. So a physical intrusion onto a constitutionally protected property for investigative purposes is a search. Okay. So the impact that United States versus Jones had, it kind of signaled a renewed emphasis on the physical trespass aspect of the Fourth Amendment. And it confirmed that a physical intrusion onto private property for those investigative purposes is a search, regardless of whether the individual had a reasonable expectation of privacy when it came to the information that was obtained. All right. And this has implications for how police use physical devices for surveillance. Now, another case that's kind of cementing this dual approach, particularly concerning the home and its immediate surroundings, is the case that I mentioned before, and that's Florida versus Jardines. So in this case, the police had received an unverified tip that Joelis Jardines was growing marijuana in his house, okay? Without a warrant, the police brought a drug-sniffing dog onto the front porch of the Jardines home, which, if you recall, as we discussed, this is the curtilage of the home, and it still receives heightened, Fourth Amendment protection. So this dog alerted to the presence of drugs, and this alert was then used as probable cause to obtain a search warrant for the home where they found marijuana. So the issue before the court was, is the use of a drug-sniffing dog on a homeowner's porch to investigate the contents of a home a search that requires probable cause and a warrant? And the Supreme Court held that the use of the drug-sniffing dog was a search, and it was unconstitutional without a warrant that was supported by probable cause or an exception to the warrant rule. And again, we have Scalia, who's writing for the majority. And similar to Jones, Justice Scalia relied primarily on that traditional trespassery test. And he emphasized that the front porch is a part of the curtilage of the home. So traditionally, this is considered part of the home for the Fourth Amendment purposes. So bringing a drug-sniffing dog, which is a specialized instrument of investigation, onto this porch to explore for evidence was a physical intrusion onto a constitutionally protected area with the specific aim of gathering information. So this physical intrusion for the investigative purposes did constitute a search. And the court explicitly stated that the police had entered the Jardines curtilage to engage in conduct not explicitly or implicitly invited by the homeowner, which was constitutionally significant trespass. Okay. So the impact that Florida versus Jardines had was that it reinforced the idea that the traditional trespass test remains a vital tool when it comes to the Fourth Amendment analysis, and particularly concerning intrusions onto the home and its curtilage. And it clarified that police cannot use drug-sniffing dogs or similar specialized tools on a person's porch without probable cause and a warrant or an applicable exception, as it constitutes a search of a highly protected area. Okay? Now, in the era of very rapidly advancing technology, the court has addressed technology and privacy beyond just the physical trespass, particularly when technology allows police to gain information that would otherwise require a physical intrusion. Okay? And I had to pause to get the name of the case because I completely forgot, and I totally forgot where I left off, but we'll just jump into the next case. So a key case in this area is Kyllo versus the United States. So in this case, federal agents used a thermal imager, which is a device that detects heat coming from inside of a building. And they used it to scan the home of Danny Kyllo, who was suspected of growing marijuana indoors with high-intensity lamps. And the thermal imager could detect heat signatures that were consistent with marijuana growth from outside the home without having to use a physical entry, okay? So, based on the thermal imaging and other evidence, agents obtained a warrant and found marijuana plants. And Kylo argued that the thermal imaging was an unconstitutional search without a warrant. So, the question before the court was, is the use of a thermal imager to scan for heat signals in a private home, which could reveal activities inside, a search under the Fourth Amendment? And the Supreme Court held that the use was a search and it was unconstitutional without a warrant. Again, Justice Scalia is writing for the majority. And the court reasoned that using this sense enhancing technology that's not in general public use, specifically to obtain information about the interior of a home that could not otherwise have been obtained without a physical intrusion, constituted a search. And Justice Scalia emphasized that the home is especially protected by the Fourth Amendment. So this thermal imager, it allowed agents to obtain information about the contents of Kylo's home that would otherwise have been unknowable without physically entering it. And so this technology crossed that firm line of the Fourth Amendment. So the fact that the technology only detected heat and not images was absolutely irrelevant, okay? And it still revealed intimate details about activities within the home that were otherwise private. So the impact that Kylo versus the United States had was that it established a principle that the government cannot use advanced technologies to explore the interior of a home that, again, would otherwise require a physical intrusion without obtaining a search warrant. And the case has significant implications for how law enforcement can use new surveillance technologies that can do things like see-through walls or gather intimate details about private lives without actual entry. So it's to ensure that the Fourth Amendment evolves to address these technological advances that essentially threaten privacy. So just as crucial as defining a search is understanding what constitutes a seizure under the Fourth Amendment. And a seizure can refer to a person or property. So a seizure of persons occurs when a police officer, by means of physical force or a show of authority, intentionally terminates or restrains a person's freedom of movement. So the key is whether, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he or she was not free to leave or otherwise terminate the encounter. And the most significant type of seizure of a person is an arrest. And so an arrest is a significant deprivation of a person's liberty, and it typically requires the highest standard of suspicion for law enforcement, which is probable cause. And that means that there must be a fair probability that the person has committed or is committing a crime. Okay? Now, not all detentions are arrests, and the Supreme Court has recognized brief detentions, sometimes called the investigatory stops or the Terry stops, which again we will discuss, that involve a less significant deprivation of liberty. And therefore, it requires a lower standard of suspicion, which is just reasonable suspicion. Now, a seizure of property occurs when there is something like some kind of meaningful interference with an individual's possessory interest in that particular property. So that could be physically taking an object, or even just preventing an owner from accessing their property for a period of time. So if that interference happens, it has to be significant, okay? So just like a search, a seizure of property must also be reasonable under the Fourth Amendment. So the central concept of the Fourth Amendment, explicitly stated in this text, is the warrant requirement. And the presumption is that searches and seizures conducted without a warrant are presumptively unreasonable and therefore unconstitutional unless an established exception applies. So this means that if law enforcement wants to conduct a search or seizure, their first instinct should be to obtain a warrant. So for a warrant to be valid, it must meet several very stringent requirements that are outlined in the Fourth Amendment itself. The first is probable cause. This is a critical standard of suspicion. So a warrant can only be issued upon probable cause, meaning that there has to be a fair probability based on reliable information that contraband or evidence of a crime will be found in a particular location or that a person has committed a crime. This is a factual determination. So it's requiring more than mere suspicion, but again, less than the proof of beyond a reasonable doubt. Now, second is peculiarity. Okay, so the warrant must, and I mean must, particularly describe the place to be searched and the persons or things to be seized. This is to prevent some kind of broad, exploratory general warrants that were a major grievance leading to the Fourth Amendment's adoption. So police cannot just search anywhere or seize anything. The warrant has to be specific, okay? Third is the oath or affirmation. So the probable cause supporting the warrant must be supported by oath or affirmation, meaning that the information presented to the magistrate must be sworn to by a reliable person who is typically a police officer. Then you also have to have a neutral and detached magistrate. So the warrant must be issued by this neutral and detached magistrate, who is an impartial judge or judicial officer who reviews the evidence independently to determine if probable cause exists. So to ensure, this is meant basically to be an objective review before there is an intrusion upon someone's privacy. So while the warrant requirement is the constitutional ideal, it is a very real reality that the majority, and I mean the vast majority of searches and seizures, they actually occur without a warrant. And this is due to a very long list of judicially created exceptions to the warrant requirement. So the Supreme Court has recognized that strict adherence to the warrant process would, in many situations, unduly impede the effective law enforcement. Okay. So these exceptions are often based on exigent circumstances, reduced expectations of privacy, or some other practical consideration. Now, let's go through some of the most common and I would say also important exceptions here. So one of the oldest and most frequently used exceptions to the warrant requirement is the search incident to a lawful arrest. So this exception allows officers to conduct a search without a warrant if it is done immediately after or contemporaneous with, meaning at the same time, a lawful arrest. Okay. So the rationale behind this exception is dual here. So the first is officer safety, and that is to prevent the arrestee from gaining access to a weapon that could harm the officer or others. And the second is to prevent the destruction of evidence. So it's to prevent the arrestee from concealing or destroying evidence that might be within either their reach or on their person. Okay. Now, the scope of this search is strictly limited to these rationales. So it has to be with the arrest, meaning it's happening at the same time or very shortly after the arrest. Okay. Now, there is a definitive case when it comes to establishing this scope of this exception, and it introduced the famous wingspan rule. That case is Chimel versus California. So in this case, police officers went to Ted Chimel's home with an arrest warrant for burglary, and they were admitted by his wife. Okay, so after arresting Chimel, the officers conducted a warrantless search of his entire house, asking his wife to open drawers and move items. They found coins and other items that were used later to convict him. Now, Chimel argued that the search of his house was unconstitutional because it was conducted without a search warrant. So the issue before the court was, does a warrantless search of an entire house conducted incident to a lawful arrest inside of the house violate the Fourth Amendment? And the Supreme Court came back and they said, yep, the search of that entire house was unconstitutional. And it established that a search incident to arrest is limited to the arrestee's person and the area within their immediate control, which is referred to as their wingspan. Now, Justice Potter Smith wrote for the majority and said that the court reasoned that the justifications for the search incident to arrest, officer safety, and preventing destruction of evidence limits the scope of the search. Okay, so an arrestee can only grab a weapon or destroy evidence from an area that is immediately accessible to them. Therefore, the search has to be confined to the area that the arrestee might reach in order to grab a weapon or some sort of evidentiary item. Searching that entire house, as they did in Chimel's case, went far beyond what was necessary for these purposes. So the court stated that there is ample justification, therefore, for a search of the arrestee's person and the area within their immediate control, construing that the phrase to mean the area from within which he might gain possession of a weapon or destructible evidence. So the impact that Chimel versus California had was that it significantly narrowed the scope of the search incident to arrest exception, again, creating that wingspan rule that is still applied today. And it's intended to ensure that this exception is strictly tied to its underlying justifications. Now, more recently, the court has clarified the application of the Chimel rule to vehicles in Arizona versus Gant. So in this case, Rodney Gant was arrested for driving with a suspended license, and he was handcuffed and locked in the back of a patrol car. And after he was secured, the officers searched his car and found a handgun and cocaine. So Gant argued that the search of his car incident to his arrest was unconstitutional. So again, the issue before the court: does the Fourth Amendment permit a warrantless search of a vehicle incident to a recent occupant's arrest when the arrestee is secured and poses no threat to officers or evidence in the vehicle? And the Supreme Court came back and said, again, yep, that is unconstitutional. It limited the scope again of vehicles when it comes to the searches incident to arrest. So Justice John Paul Stevens wrote for the majority and said that the court recognized that the justifications from Chimel, which is officer safety and destruction of evidence, are often not present when an arrestee is secure. So the court held that the police can search a vehicle incident to a recent occupant's arrest only, and I mean only if the arrestee is within reaching distance of the passenger compartment at the time of the search, meaning that they could still access a weapon or some kind of evidence, or it is reasonable to believe that the vehicle contains evidence of the arrest or of the offense of the arrest, basically. So, for example, if arrested for drug dealing, it's reasonable to look for drugs in the car. Okay. Now, in this case, since Gant was handcuffed in the patrol car, posed no immediate threat to the officers or to evidence in his vehicle, and the offense was driving with a suspended license, it would not have evidence in the car, so there was no justification applied and the search was unreasonable. Again, the impact of Gant was that it significantly limited the scope of vehicle searches incident to arrest, making it harder for police to conduct such searches once an arrestee is secured. So it forces police to rely on other exceptions, like the automobile exception, which requires probable cause for evidence of a crime in that car, if they want to search a vehicle after an occupant has been arrested and restrained. So the exigent circumstances exception recognizes that certain emergency situations may justify police action without a warrant because there is simply insufficient time to get one. So the situation must be truly exigent, meaning that it's urgent and it demands immediate action, and that outweighs the need for the warrant. And there are several scenarios that are very common when it comes to exigent circumstances that may apply. And the first is hot pursuit of a fleeing felon. So if police are in immediate pursuit of a suspect who they believe, like they have probable cause to believe that they have committed a felony, and that suspect flees into a private dwelling, then the police can follow the suspect into the dwelling without a warrant. Okay. The exigency here is the need to apprehend the suspect and to prevent escape. It also could be to make sure that they do not destroy evidence. But for example, if you have, say, police chasing a bank robbery suspect who, after like a brief foot chase, they run into what appears to be a residential house, the police can immediately follow them in without waiting for a warrant. Now, a case that illustrates this specific application is United States versus Santana, which, by the way, is one of my favorite cases. But it clarifies the concept of public versus private when it comes to the threshold of a home, okay? The threshold being the area where your door shuts and your door frame, basically. So police had probable cause to believe that Gloria Santana was involved in selling heroin. And when the officers arrived at her house, they saw her standing directly in the doorway, holding a brown paper bag. Now, there's a whole bunch more that goes to this case. Like I said, it's my favorite one, but this is the best way I can kind of sum it up. So as the police officers approached and identified themselves, Santana retreated into her house, attempting to close the door. And the officers immediately followed her into the house without a warrant. They arrested her and they found heroin and marked money inside of this bag. So the issue was, could police, again, acting in hot pursuit, lawfully enter Santana's home without a warrant to complete her arrest, given that she was initially visible and retreated into her home was, it was provoked by police. And the Supreme Court held that Santana was in a public place when she stood in her doorway, okay? And that the police were in hot pursuit of a suspect who had retreated into a private dwelling, thus justifying their warrantless entry and their arrest. And the evidence was found to be admissible, okay? So Justice William Rehnquist wrote for the majority and said that a person standing in the open doorway of their home is in a public space for the Fourth Amendment purposes, as they are exposed to the public view and they have no reasonable expectation of privacy. So when Santana retreated into her house, the officers were then in hot pursuit of a suspect who had just committed a felony. It was an undercover deal with drugs. Anyhow, so the court stated that a suspect may not defeat an arrest which has been set in motion in a public place by the expedient of escaping into a private place. So the exigency was the need to prevent or to complete the arrest, rather, and to prevent the destruction of the evidence, which would have been the heroin and the money that she was seen holding. Therefore, this warrantless entry to complete this arrest in hot pursuit was justified. So the threshold of the home, when a person is standing openly in it, blurs that line between public and private for initial encounter purposes. Okay. So the impact here is that United States versus Santana clarified that the doorway of a home, when a person stands there open to public view, can be considered a public place for the purposes of initiating an arrest or hot pursuit. And it established that police, once they have lawfully initiated an arrest in a public place, are not required to stop at the threshold of a home if the suspect attempts to retreat inside, so long as true hot pursuit and exigent circumstances exist. Okay? So this case emphasizes the legal distinction between being inside of a home, which is highly protected, and being exposed to the public, well, the public view at the threshold. Okay? Again, we have that imminent destruction of evidence. So if police have probable cause to believe that the evidence is about to be imminently destroyed, again, they can enter into the home without a warrant to prevent its destruction. And again, you might have where police are chasing somebody from outside of an apartment. They hear a flushing toilet repeatedly and loud shouts about, let's get rid of the stash, while they have, that's probable cause to believe that drugs are inside. Okay. This might also be justified in entering the private in the private home to prevent the destruction of the evidence, okay? As waiting for a warrant would likely result in the evidence being lost. Now, some other exceptions include emergency aid, and this is sometimes referred to as the community caretaking function. So, if police reasonably believe that someone is in danger or seriously injured inside of a dwelling, then they can enter that dwelling without a warrant to render aid. But the key is a reasonable belief that an emergency exists that requires immediate action to protect life or prevent some kind of serious injury. So, for example, if police respond to a 911 call that there have been screams reported coming from inside of a house, or maybe they see somebody who's unconscious inside of a car, then they can enter in order to provide immediate assistance. Now, another one is preventing the suspect's escape. So, if police have probable cause to believe that the suspect will escape before a warrant can be obtained, then they can take action to prevent that escape. And that's usually very narrowly applied, and it's often in conjunction with hot pursuit. But the burden is always going to be on the government to prove that truly exigent circumstances existed at the time of the warrantless search and seizure. The emergency cannot be something that is created by the police themselves. Now, another important exception, which is often confused with search incident to arrest for vehicles, is the automobile exception. And this allows police to search a vehicle without a warrant under specific conditions, largely unique or largely due to the unique nature of the automobiles. Now, the rationale for the automobile exception is twofold. One is there is a reduced expectation of privacy. So people generally have a reduced expectation of privacy in their vehicles as compared with their homes. And that is due to extensive government regulation of vehicles. You have licensing, registration, all of those things, and their open visibility on the public roads. So what you do or store in your car is often more exposed to public view than what you do in your home. The second is the inherent mobility. And vehicles are inherently mobile, meaning that evidence or contraband that's inside could easily be driven away or disappear before officers obtain a warrant. So this factor makes it impractical to always require a warrant for vehicle searches, okay? So the requirement for this exception is that police must have probable cause to believe that the vehicle contains contraband or evidence of a crime. This is the same probable cause standard required for a warrant. So the exception simply bypasses the warrant itself due to the vehicle's unique characteristics, okay? So the scope of the search under the automobile exception is quite broad. So if police have probable cause to search a vehicle for a particular item, they may also search any part of the vehicle and any containers within it where that evidence might be reasonably found without a warrant. This includes the passenger's compartment, the trunk, the glove compartment, any bags, boxes, any other kind of containers that could conceal a suspected item. And the scope is defined by the object of the search and the places where there is probable cause to believe that it may be found, okay? The important thing here, though, is that mobility is not always strictly required at the moment of search. So if police have probable cause to search a vehicle, then they can conduct the search even if the car is, say, impounded or not otherwise immediately mobile, as long as probable cause existed before that vehicle was immobilized. So the initial justification for the exception, the mobility part, it applies even if the vehicle was not actually about to be driven away at the moment of the search. So, for example, if police stop a vehicle and an officer detects a strong smell of marijuana coming from inside of the vehicle, then they have probable cause to believe that there are drugs inside. So under the automobile exception, they can immediately search the entire vehicle, meaning the trunk, any containers, anything that can hold marijuana without first obtaining a search warrant. The plain view doctrine is another common warrant exception, which allows officers to seize evidence without a warrant if it is discovered in plain view during a lawful observation. Now, there are three key conditions that have to be met for the Plainview Doctrine to apply. And the first is that the police must be legally present in the place from which the evidence is being viewed. This means that the officer must not be violating the Fourth Amendment or any other law to be in a position to see the item. So, for example, if an officer is conducting a lawful traffic stop and sees something in the car, or they're executing a valid search warrant for another crime and sees the contraband, or lawfully on a private property, like with permission, then they meet this condition. They cannot illegally enter a home and then claim plain view. The second is that the incriminating nature of the item must be immediately apparent. So this means that the officer, at the time that they see the object, must have probable cause to believe that it is contraband, which could be not necessarily just contraband. It could be evidence of a crime. It could be an instrumentality of a crime, but without manipulating the object or conducting any further search, it has to be apparent, okay? So they can't move it around. They can't open it. They can't shake it to do something to figure out what it is. Its incriminating character has to be obvious at that first glance, okay? And the third is that the police have to have a lawful right of access to the object itself. So even if an object is in plain view and its incriminating nature is immediately apparent, the police cannot simply trespass or violate another constitutional right to seize it. So, for example, if an officer sees contraband through a window of a house while standing, on a public sidewalk, they can't enter the house to seize it without a warrant or some other kind of an exception, like in exigent circumstances. They have to have a lawful way to get the item. Okay. So a simple example would be, an officer lawfully stops a car for a traffic violation. As the officer comes up to the driver's side, they look inside and clearly see a bag of white powder that, based on their training, is immediately identifiable as cocaine, and it's sitting in plain sight on the passenger seat. Now, in this scenario, you have all three conditions that have been met, and the officer would be able to seize the drugs without a warrant. The final exception that we're going to discuss is consent, and this is a very powerful exception because it allows individuals to voluntarily waive their Fourth Amendment rights. And a search is constitutional if police obtain voluntary consent from someone with actual or apparent authority to give them that consent. And this exception is based on the idea that an individual can choose to allow an intrusion into their privacy. And there are three key requirements for consent to be valid. The first is it has to be voluntary. So the consent must be freely and voluntarily given. It can't be coerced, okay? This means that police cannot obtain consent through threats or intimidation or trickery or falsely claiming that they have a warrant, okay? Courts are going to look at the totality of the circumstances to determine voluntariness. They're going to consider factors like the individual's age, their intelligence, their education, are there any language barriers, were they in custody, or whether they were informed of their right to refuse consent, though police are not generally required to inform them of that right. The second is the authority to consent, and the person giving consent must have the legal authority to do so. Now, we have actual authority, and that means the person giving consent actually has control over the area or the property that's being searched, like the owner of the house, a leaseholder for an apartment, a driver for the car, a person for their, own bag, whatever. Then you have apparent authority. So this is where even if the person doesn't have actual authority, the search can still be valid if it reasonably appears to the police that the person does have authority. So for example, if a person answers the door and they have a key and they claim to live there, then police may reasonably rely on that, even if it turns out that they moved out last week. The third thing is scope. And the search cannot exceed the scope of the consent that is given. So if a person consents to search only their living room, then police can't go to their bedroom unless they find something during that living room search that creates probable cause enough for an expanded search or another exception to apply. So for example, If police knock on a homeowner's door and they ask, may we come in and search your garage for a stolen bike? If the homeowner who owns the garage clearly and voluntarily says yes, then the police can lawfully search the garage for the bicycle without a warrant. Okay. Now, if the homeowner only says, well, you can only look in my living room, the garage is off limits under that consent because we're stuck to the living room. All right. Now, we have discussed arrest as a seizure of a person, but what about brief detentions? I've brought this up several times already, so let's just get into it. These are less than a full arrest, okay? This is where the stop and frisk doctrine comes in, and it was established in Terry versus Ohio. And this exception balances the need of law enforcement for officer safety and crime prevention against individual liberty and privacy by allowing for brief, limited intrusions based on a lower standard of suspicion rather than probable cause. So, Detective Martin McFadden was a veteran police officer, and he was patrolling downtown in Cleveland. And he observed two men, John Terry and Richard Chilton, and they were repeatedly pacing back and forth in front of this store. And they were looking into the window and they were chatting with each other. And then they met up with a third man. Now, based on Detective McFadden's experience, he suspected that they were casing the store for a robbery. And he approached the men, identified himself as a police officer, and he asked them for their names. And when they mumbled a response, he feared they might be armed. He then frisked Terry and Chilton, patting down, their outer clothing. And he found a pistol in Terry's coat pocket and another in Chilton's pocket. And he removed the weapons, and the men were subsequently charged with carrying concealed weapons. They argued that the stop and frisk violated their Fourth Amendment rights because it was conducted without probable cause for arrest or a warrant. So the issue before the court was, did the stop and frisk of Terry and Chilton, which was conducted without a warrant or probable cause, violate their Fourth Amendment rights against unreasonable searches and seizures? And the Supreme Court held that this was reasonable. It was a reasonable search. It was a reasonable seizure given those circumstances, and it upheld the convictions. And it created a specific exception to the warrant and probable cause requirements for these limited intrusions based primarily on officer safety. So Chief Justice Earl Warren wrote for the majority, and he said the court recognized that stopping and frisking a person is indeed a Fourth Amendment seizure and a search, even if brief and limited, okay? But he also recognized the urgent need for police to be able to take swift action for their own safety and to investigate suspicious activity without having to meet the higher standard of probable cause for a full arrest. So the court created this two-part test for a lawful stop and frisk. The stop, which is the seizure of a person. This is where an officer can briefly detain a person for investigative purposes if they have reasonable, articulable suspicion that criminal activity is happening. So this is a lower standard than probable cause, and it has to be based on specific, objective facts that the officer can articulate. And again, those rational inferences drawn from those facts it's more than just a hunch, okay? So in Terry, the detective's observation of the suspicious pacing back and forth, looking in the window, conferring with each other, meeting the third person, all of that stuff met the standard, okay? Now, the second is the frisk, and that is the search of the person. So if, after a lawful stop, the officer has a reasonable suspicion that the person is armed and dangerous, then they can conduct a limited pat down of the outer clothing for weapons. And that pat down is strictly for weapons, not for evidence of a crime. And its scope is going to be limited to what is necessary to determine if the person is armed. And again, this justification is purely for officer safety. But the court found that, Detective McFadden's actions met both of those prongs. And they said that his observations of the men's, their suspicious behavior provided reasonable suspicion to stop them and his reasonable fear that they may have been armed given the suspected crime and his experience. And it provided reasonable suspicion for them to frisk them for weapons. Now, the impact of Terry versus Ohio, this was a landmark decision, and it created a new lower standard of reasonable suspicion for these brief detentions and these limited searches, which we're calling frisk, okay? And this significantly expanded police power to intervene in suspicious situations based on less than probable cause. So, again, it's to balance the individual liberty with officer safety and crime prevention. But it also has been a source of significant controversy, particularly regarding its application in situations that disproportionately affect minority groups, leading to concerns about racial profiling and over policing, as those articulable facts, those can sometimes be subjective. So, beyond the general rules and exceptions, the Supreme Court has recognized that in certain special circumstances, individuals have a reduced expectation of privacy, which can lead to more permissive searches under the Fourth Amendment. This general principle is applied in several different contexts. So, one would be probationers, parolees, these individuals who have been convicted of crimes and have been released on probation or parole often have significantly diminished Fourth Amendment rights. As a condition of their release, they have to frequently submit to warrantless searches of their person, their home, their property. Even without an explicit agreement, the Supreme Court has held that probation officers typically only need reasonable suspicion, not probable cause, to search a probationer's home because the state has a heightened interest in supervising probationers and preventing recidivism. So the state's interest in rehabilitation and protecting the community outweighs the probationer's reduced expectation of privacy. Now, prisoners is a little bit different. So once an individual is incarcerated, they have a very limited expectation of privacy within the prison setting. So searches of prison cells, persons, and property are generally going to be permissible without, warrants and probable cause, as they are seen as necessary to maintain institutional security and order and safety and to prevent, even the smuggling of contraband. So the safety and the security needs of the correctional facility are going to heavily outweigh any kind of residual, privacy interests. Now let's talk about students in public schools. The Supreme Court has held that students in public schools have a reduced expectation of privacy while they are on school grounds. So school officials who are acting as agents of the state and not law enforcement generally only need reasonable suspicion, again, not probable cause or a warrant, to conduct a search of a student's person or their belongings. And this is because the school environment requires a balance between students' privacy rights and the school's compelling interest in maintaining order, safety, discipline, and a proper learning environment. So, for example, if a principal has a reasonable suspicion that a student has drugs in their locker, then they can search it. But highly intrusive searches like a strip search is generally going to require a higher level of suspicion. And these categories highlight how the Fourth Amendment's protections are not uniform across all contexts, but they are often adjusted based on the specific setting and the nature of the government's interests. So, as we wrap up, I want to talk about a very important part of the Fourth Amendment's enforcement, and that is the exclusionary rule. And this rule is not explicitly mentioned in the Constitution. It is a judicially created remedy, meaning that the courts developed it, and that it prohibits the use of evidence that is obtained in violation of the Fourth Amendment or other constitutional rights, though for our purposes right now, we're focusing on the Fourth Amendment, but specifically in a criminal trial. And the primary purpose of the exclusionary rule is deterrence. It is to deter the police from misconduct and to compel them to adhere to the Fourth Amendment. So the idea is that if police know that this illegally obtained evidence cannot be used in court, then they will be less likely to violate the individual's Fourth Amendment rights during searches and seizures. Again, this is probably another area where you're going, I've got questions, I can raise some arguments. And there are all kinds of cases for this that absolutely will do that. But we're talking about it in an overview. And again, it aims to prevent the government from benefiting from its own constitutional violations by presenting this evidence that it obtained through unlawful means. And it's meant to ensure that the Fourth Amendment has some teeth, okay, that it can bite. And so for decades, the exclusionary rule only applied to federal law enforcement, meaning that state police could still illegally search someone and use the evidence in a state trial. This changed dramatically with Mapp versus Ohio, which incorporated the exclusionary rule to the states, making it a nationwide standard. So in this case, police in Cleveland, Ohio, which a lot of things seem to happen in Ohio, but they received a tip that a suspect in a bombing case was hiding in Dalry Mapp's home, and that Mapp was also hiding illegal gambling paraphernalia. So police went to her home and demanded entry, and Mapp refused to admit them without a warrant. So after several hours, police forced their way into her home, claiming that they had a warrant, though no warrant was ever produced or later found. But they searched the entire house, including her basement, her bedroom, even a trunk inside of the basement. And in this trunk, they found obscene materials. And Mapp was arrested and convicted for the possession of these materials. And she argued that the evidence was obtained through an illegal search and seizure, violating her Fourth Amendment rights. So the issue before the court was, is evidence obtained through an illegal search and seizure in violation of the Fourth Amendment admissible in a criminal state proceeding? Okay. And the Supreme Court said, that it's not admissible. Okay. So it's the same. We're incorporating it through the 14th Amendment. And the ruling made the exclusionary rule applicable to the states. Okay. Creating this nationwide constitutional standard. So Justice Tom Clark wrote for the majority and said that the court reasoned that if the exclusionary rule did not apply to the states, then the Fourth Amendment's guarantee against unreasonable searches and seizures would be rendered kind of meaningless at the state level. So Justice Clark stated that all evidence that's obtained by searches and seizures in violation of the Constitution is, by that same authority, inadmissible in state court. And he argued that without the exclusionary rule, the Fourth Amendment would be a mere form of words. It's lacking the teeth, okay? And he concluded that the exclusionary rule was essential to ensure compliance with the Fourth Amendment by police officers and to maintain judicial integrity, thus preventing the courts from becoming accomplices in these constitutional violations. So the impact of Mapp versus Ohio was a huge decision, a highly significant decision. It extended that exclusionary rule, which again had only previously applied to federal law enforcement, to all state and local police forces across the country. And that fundamentally reshaped criminal procedure nationwide, making illegally obtained evidence inadmissible in all criminal trials in the United States. And it established the exclusionary rule as the primary mechanism for enforcing the Fourth Amendment, thus compelling police nationwide to adhere to its requirements. There's the good faith exception. And this exception allows evidence obtained by officers acting in reasonable reliance on a search warrant that's issued by a neutral magistrate, even if the warrant is later found to be technically defective. Like, for example, maybe due to a technical error by the judge, not the police, and it allows it to be admissible. So the rationale is that if the officer acted in good faith reliance on what they believed was a valid warrant, then the deterrent purpose of the rule, which is punishing police misconduct, is not served by excluding the evidence as the police behavior was not culpable. Next is the inevitable discovery doctrine. And this doctrine allows evidence obtained illegally to be admissible if the prosecution can prove by a preponderance of evidence that the police would have inevitably discovered the evidence through lawful means, anyhow, regardless of this initial illegal search. So, for example, if police illegally search a body and they find evidence, but they can show that a lawful search team was already systematically kind of sweeping the area and would have found the body and evidence regardless, then the evidence might be admissible. And last but not least, we have impeachment. So while illegally obtained evidence cannot be used by the prosecution to prove a defendant's guilt in the main part of their case, which is the case in chief, it can sometimes be used to impeach or challenge the credibility of a defendant who testifies in their own defense. And they offer testimony that's inconsistent with the illegally obtained evidence. So this is to prevent defendants from committing perjury on the stand. So that's pretty much it. We've talked about what constitutes a search and seizure. And we've talked about how they have moved from this strict trespass standard to the reasonable expectation of privacy, and then back to acknowledging the importance of the physical trespass, especially in a technological age. Okay. We've talked about the foundational role of probable cause, the lower standard of, reasonable suspicion. And when we look at the warrant requirement, the ideal is that the strict criteria for probable cause and particularity is, ideally enough. Okay. But that's not the case because we have to have these exceptions. Okay. And again, that includes the search incident to lawful arrest. You have the automobile exception, the plain view doctrine, you have exigent circumstances, consent, stop and frisk, and there's so many more, but we're not going to touch on all of them. But again, we also talked about the reduced expectation of privacy in certain situations like prisoners, probationers, students, parolees, things like that. And then we looked at the vital role that the exclusionary rule plays and how it was incorporated to the states by Mapp versus Ohio. And again, this is the primary enforcement mechanism for the Fourth Amendment, again, to deter police misconduct while also acknowledging that it has various limits and exceptions, okay? But ultimately, the Fourth Amendment is about, a fundamental tension, the tension between individual liberty and privacy. So ensuring that our security in our persons, houses, papers, and effects versus the government's legitimate and necessary interest in public safety, crime investigation, and effective law enforcement. And again, the Supreme Court's interpretation of reasonableness and privacy, they're not static. They continue to evolve, sorry, it's like 2 a.m., with new technologies, the societal changes, and even ongoing debates about the proper balance between freedom and order. And this is a complex but an immensely practical area of law, and it impacts the interactions between citizens and the police every single day. So understanding these principles is fundamental to understanding your rights and limits in when it comes to governmental power. And if you work in criminal law, this is all you're going to be dealing with is stuff like this. But anyhow, if you have any questions, please make sure to reach out to me. Bye.